Hello, and welcome to CFSS TV. I'm Ron Weber with the CEO of CFSS, Mohammed Fahim, and Chuck Krugel.
Thank you, Ron. Chuck Krugel is an employment law attorney, and Chuck, let's talk about employment law for employers. What do employers need to know in order to avoid getting into trouble on the back end? Let's start off with some best practices for onboarding. What would you suggest?
Sure. I think the onboarding serves sort of two purposes. One is to orient the employee to the company culture, to the workplace itself, their coworkers. And the other aspect of it is for the employer to sort of CYA, to cover their butt relative to legal issues, things like that, training on harassment, discrimination, any wage and hour disputes, open door policy, that type of stuff.
So when you say onboarding now, is having an employee handbook part of the onboarding process, and how important it is to have an employee handbook in place?
All right. If you have a handbook or you want a handbook, then it's extremely important to have a good handbook. So you just don't have a boilerplate language that you cut and pasted from the internet, so that's relevant to your actual workforce and workplace culture. Otherwise, you're going to have a lot of problems. It's going to be incongruent.
Now, would that handbook, again, I'm kind of getting more into the handbook aspect of it because we have had this discussion before. Would that handbook be different for the C-level executives versus, the floor kind of executives, or the white collar and the blue collar employees, or is everything going to be covered in one handbook?
It's probably, from a logistical standpoint or efficiency, it's probably best to have it in just one handbook. But if you're a very complex company with a lot of different divisions and very hierarchical, it might be better to have separate handbooks for the different levels of employment, because there could be confidentiality concerns or just issues that one group of employees just don't run into.
Chuck, what laws should the employees be trained on, if any?
Well, discrimination and harassment are the most obvious ones. Those are the ones that seem to get most employers in trouble when they don't properly train their employees. And yet, if you're going to train your employees, train them all on it, including all the C-level employees, even the board members. So this way you could cover yourself and also properly train them on how to resolve these disputes at the ground floor level, as opposed to them escalating to a third party like an attorney or the Equal Employment Opportunity Commission.
Can you give a couple of examples of what kind of situation would escalate up to the EEOC?
Sure. Well, any situation really that an employer doesn't properly address it at the ground floor level. So if an employee comes to an employer with a complaint and the employer doesn't address it properly or sufficiently, adequately, whatever, or timely, then the employee's they're going to look to an outside source for remedy, like the Equal Employment Opportunity Commission or their own attorney. So that you could pretty much bank on it that almost invariably any time the employer doesn't properly address the issue, the employee is going to look for an outside remedy.
Okay. So when you say properly address the issue, how important is to document all these steps that an employer is taking?
Well, if you're doing the investigation, then documentation is going to be key. So and especially like if you have a handbook. So if you've documented one thing copiously, such as in a handbook, and then you conduct investigations and don't document those, there's an incongruency there, and that's going to be problematic down the line. So if you're documenting some aspects of your business, then make sure you're documenting all aspects of your business, including employment investigations, complaints, and how they're resolved.
Okay. Sometimes I have seen that when employers are not documenting things properly, and I know that Illinois, for example, is an at-will state.
Sure.
Explain the at-will state to our audience for a second as to what does at-will mean?
Sure. At-will is a doctrine that basically says an employee can be fired from a job at any time for any reason, with or without cause or notice, by the employer. And conversely, an employee can leave the employer's workplace anytime for any reason, with or without cause or notice, too.
Ron, something interesting comes in at this point. When you say without cause or notice, there's this impression out there that you have to give a 15-day notice if you want to resign or quit from a job. Is that required by law, or is that just something out there that people have been talking about for a long time?
I've actually researched this because I've discussed this with clients. There is no law about that, and where the 15 days or 14 days, 2-week notice idea comes from, nobody knows. I've actually
Okay.
gone in depth on the internet to research this and couldn't find out why.
So it's just one of those jungle folklores
Yeah.
out there that you have
Yeah.
to give a 15-day notice.
Yeah.
Now, from a PR perspective, if you're going to use that employer as a referral, I would definitely say that give some notice, because the employer has to replace you with another employee, and it takes time to get another employee in place.
It's
Ron,
courtesy.
yeah, it is a common courtesy. So any other suggestions that you have for employers as far as the onboarding process is concerned?
Yeah, engage your employees in it. If it's just a lecture with people talking at the employees, I don't think it's going to be effective. If you want your employees to learn the culture and the workplace and the rules, engage them in the onboarding process. Make them feel a part of it.
Now, that is something that we can help you out also at CFSS. So if you are looking for some help, you can reach out to us. You can send out an email to info@cfss.us, and we will be happy to come and talk to you. The initial consultation, there's no charge for that, and then we can connect you with experts to make sure that you are following the law as it is supposed to be followed. And check if an employer wants to work with you, how can they reach out to you?
They could just Google my name, Charles Krugel, Krugel. There's not too many people in the world with my last name.
Okay.
So, and it should come up for labor and employment law.
So what happened to the last Krugel before you? Was he an attorney and somebody got him, or
It's funny you ask that. I actually once did a search. And there's some guy with the same name as me in Los Angeles.
Okay.
I found out about him a number of years ago through a marathon list of marathon participants. I don't know where he's at anymore.
Okay.
So yeah,
He probably kept on running and never stopped.
yeah. Ran south of the border and just kept going to the.
Yeah, folks, we have Chuck Krugel in the studio with us today, employment law attorney, management side. That is how you like to brand yourself.
Yeah, exactly.
What is the difference between a management side employment law attorney and a people side employment law attorney?
I represent the employers. So
Okay.
what I'm doing is either defending them against wage and hour disputes, discrimination, harassment disputes, or any other sort of maybe a labor union dispute, or I'm prosecuting on behalf of the employer an employment agreement, such as post-employment restrictions, confidentiality agreements, things like that. Whereas a plaintiff side or employee side attorney represents the employee before the employer or in front of the Equal Employment Opportunity Commission or court, whatever.
Now, do you represent employers in hearings at the unemployment office also?
Yeah, actually, yeah, I do.
Okay.
Interesting bureaucracy.
Well, thank you for enjoying this presentation. This is Ron Weber, Mohammed Fahim, and Chuck Krugel for CFSS TV. Have a great day.